We want to bring in a team of legal experts speaking to Tanya Cross-Phelan and Andrew Rodenhouse. Andrew, Tanya, what are your initial reactions of hearing Schurr take the stand?
Well, I jotted down a couple of notes. My one big takeaway I had was that he testified that he didn't know that the taser had deployed a second time. What that would mean that in his mind, that Patrick was getting a taser gun that still had another two prongs to shoot out and do the to hit him with, and so we had all this testimony from these experts about using the taser in drive stun mode. But what we learned today from Officer Schurr's testimony is that he thought that it still had another charge in it for using the prongs. And so he testified that he was trying to reach down to shut the taser off in the hopes that that now that Patrick has it, that he wouldn't be able to figure out how to use it. And when that failed is when he decided that he needed to fire the fatal shot. And so that was interesting because we've never heard that story before. We've never heard from him. And remember, the officers have to make a statement after an incident like this, and so it'll be interesting to find out whether or not he made that in the original statement. Because if he didn't, then I would expect Mr. Becker to impeach him with his prior statement.
And Tanya, can you add to that? What are your initial reactions?
My initial reactions are that this was a difficult thing for Mr. Schurr to go up and testify about. I think the observation about starting off by saying he's not comfortable speaking in public sort of set the expectations for how he might come across to the jury. He was very calm, but you could tell he was uncomfortable. And then the other dynamic that's at play here is he's an officer, so he's an expert, if you will, on how to respond to these types of things. So he's talking in that capacity, but yet there's this very real human aspect on the other side of it. So that was really interesting. And to one of the points that Andy just made, you'll recall back when Mr. Bloomfield was testifying and the defense cross-examined him about this aspect of auditory exclusion. What we're going to start seeing when we get to closing arguments is how the lawyers piece together all the bits and pieces of the evidence we've heard throughout the trial to craft that closing argument. And I want to link that idea of auditory exclusion to what Andy just pointed out, that Mr. Schurr testified that he never heard that second taser being deployed and how that affected his state of mind. And we know by tying that back to the testimony about the idea of auditory exclusion, there's legitimacy, to Mr. Schurr's statement that he never heard that second shot. So I thought that was very fascinating.
Andrew, I want to bring up a point that you made about the statement on which Schurr would have had to write after this entire incident a few years ago. I can tell you right now, I'm reading the live blog that we have up on 13onyourside.com, and it's already being put in front of Schurr's face. Actually, I just watched them put documents in front of his face, and they're pointing at things as they go down through that report. What is the strategy that the prosecution is using here to go through that report like how they are on the stand?
Well, it's just simple impeachment. It happens in every trial with nearly every witness. If they have made a prior statement or they have a statement that has been used previously, you're allowed to impeach them with what's known as a prior inconsistent statement. And so oftentimes when an officer has to make these Garrity statements, they're cautioned by their because they usually will have a union representative with them or an attorney paid for by the union with them. They're oftentimes cautioned to not give specific details so that basically it gives them a little bit of a leeway in the future. And what I would expect is that after cross, Mr. Dodge, who I thought has done a great job so far walking him through his testimony, I expect that he's been instructed, don't argue with the prosecutor because that just makes you look combative. He's probably been instructed, let him have his points if he's getting a point, and then we'll come back in on redirect and then clean anything up as it pertains to any inconsistencies, and then you'll be allowed to explain away why there's an inconsistent statement.
And Tanya, we have heard both you and Andrew talk about the building blocks the defense has started to create their case. Do you think what we've seen so far from Schurr, has that confirmed that the building blocks are working? Has he stayed on track? What are your thoughts on that?
From the defense perspective, yes. Again, all of the witnesses that were presented by the defense yesterday laid very specific building blocks, if you will, for aspects of the self-defense elements, right? What Mr. Schurr was thinking at the time, how certain things would have affected him physically, how it might have affected him emotionally or mentally. So all of that lays the idea that what Mr. Schurr is testifying to today is not something he's just making up to try to get out of a criminal charge. It's really plausible that what he's testifying to is true because of everything these other experts have said. And I think Mr. Becker has some strategic decisions to make with how he cross-examines Mr. Schurr. As we've talked about already, Chris Becker is an excellent prosecutor, and he is a rigorous cross-examiner. And the strategy here is, do you attack Mr. Schurr in sort of a aggressive manner, or do you be pretty matter of fact with him and let the facts speak for themselves as you cross-examine him? Do you try to rile Mr. Schurr while he's testifying so that the jurors might see a different side of him? So I'm really curious to see Mr. Becker's strategy for cross-examination.
Let's talk about the exhaustion and fear aspect of all of this. Of course, that's been a major topic and a major sticking point for both sides as they try to argue their case. Can you kind of explain to us, when Schurr is up on the stand talking about how exhausted or how afraid he might have been in that scenario, what does that do for the jury? Is it just enough for him to say that, or do we need that concrete proof to show those two things?
Well, you got to remember the burden is on the prosecution again, and so he doesn't have to show anything. It's the prosecutor that would have to show that. In fact, the prosecutor would have to say that that's not true and somehow demonstrate that that's not true. And that's what I think he's going to try to do in cross-examination. But as Professor Krauss-Phelan said, you know, the defense did a really good job of drawing out of the prosecution's experts stuff that they would want to then support Mr. Schurr's position that, hey, I didn't recognize that there was a second taser deployment. I heard it described once as just tunnel vision. Like, he's in this fight, all his blood is going to his muscles, his big muscle groups. So like, there's not a lot of blood operating up here in your vision space and in your hearing, because all your energy is being put into this other area. And so it's quite possible he was not aware of that. In fact, and they were able to elicit that from the prosecution's expert.
And I would love to hear your opinion on this as well, Tanya.
Yeah, I think, now remember, the two witnesses that we had yesterday, Bartel and Kroll, they each lended expertise to both the exhaustion and the biochemical type of reactions in the body to this kind of situation, as well as the taser. But so we have that testimony that the kind of physical reactions the body is going to have to this stress level and this particular type of situation. But it's not just the defense experts. You can actually hear on the tapes, on the videos, the level of his breathlessness. And it's later seen both by the responding officers and their body cameras, the level of physical exhaustion. So again, these building blocks have been laid very strategically to support what was anticipated to be Mr. Schurr's testimony. And why it all matters is because when the judge, after closing arguments, gives the jury those final jury instructions, she will instruct them that they have to look at this from his perspective at the time, right? They're told that they have to look at it from his perspective at the time. So all of this, Schurr's testimony, supported by all of the underlying testimony that came before him, supports that notion that defense will argue he was in fear of imminent death or great bodily harm, and his physical state at the time lends to that belief.